Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court justice. With me, Jill Barton. Today, our AI hosts explain the ranking of legal authorities, also known as the hierarchy of authority. This ranking matters because it will determine which authorities have precedent to govern any legal question you might need to analyze. Let's listen in.
Welcome back to the deep dive. Ever felt, a bit lost trying to wade through some really dense information, maybe a complex policy or a new regulation? How do you figure out what's the actual rule versus what's just commentary? Today, we're diving into the hierarchy of authority in the legal system. It's this framework that gives you a surprisingly clear roadmap, not just for law, but really for navigating any kind of complex information overload.
That's exactly right. Our goal here is to basically pull back the curtain on how legal sources get ranked. We'll look at the differences between, say, law and commentary, federal versus state law, and how courts actually create rules that other courts have to follow. And it's not just legal theory. Knowing this stuff gives you a solid playbook for thinking strategically, especially when you're dealing with complicated material.
Okay, let's dig in then. When you're faced with a legal question, how do you even know where to start? What's the real deal, the actual law, compared to just someone's opinion about the law?
That's really the first hurdle. You've got primary authorities. That's the law itself. Think of it as the official rule book. We're talking constitutions, statutes passed by legislatures, the actual written opinions from courts, and regulations from government agencies. That stuff is the law.
Okay, so primary is the law. What about things like legal encyclopedias or those long articles in law journals or even textbooks?
Right, those are what we call secondary sources. They talk about the law, they analyze it, they explain it. They can be incredibly useful, for getting your head around a topic or, importantly, for pointing you towards the right primary sources. But crucially, they are not the law itself. You generally wouldn't cite a law review article in court as binding legal authority.
Makes sense. So primary is law, secondary is commentary. But even within primary sources, the actual law, I'm guessing not everything carries the same weight. There's like a pecking order.
Exactly. There's definitely a hierarchy. Think of it kind of like a pyramid. Right at the very top, the peak, you have constitutions. The U.S. Constitution is the supreme law of the land. It has what's called the Supremacy Clause, which basically means no other law, federal or state, can conflict with it. It's the ultimate trump card.
So wait, if Congress passes a law, a statute, but it clashes with the Constitution, the Constitution just wins. The statute gets knocked out.
Absolutely. It's declared unconstitutional and void. A famous example you might know is United States v. Windsor. The Supreme Court struck down part of the Defense of Marriage Act because it violated the Constitution. So constitutions are at the top. Then, just below them, you have statutes. Those are the laws passed by Congress or state legislatures. Below statutes, you find case law. These are the published opinions from courts interpreting those constitutions and statutes. And then, sort of at the base, you often have regulations, rulings, ordinances, usually created by government agencies acting under power given to them by statutes.
Okay, that pyramid structure helps. Constitutions, statutes, cases, regulations. Got it.
And what's fascinating is how much lawyers actually rely on that third level, case law. Even when they're trying to understand the Constitution or a statute, they look at how courts have interpreted it.
Right, because the court opinions explain what the higher-ups actually mean in practice. Okay, so let's talk about those court opinions, the case law. It sounds like that's where things get really detailed.
They do. And the first thing to grasp is that the U.S. has, broadly speaking, two parallel court systems. The federal system and the state systems, one for each state. Both systems typically have tiers. Trial courts, where cases start, intermediate appellate courts that review trial court decisions, and a highest court, like the U.S. Supreme Court or a state Supreme Court.
And each court has its own jurisdiction, right? Like its area of authority.
Precisely. Jurisdiction defines what kinds of cases a court can hear and the geographic area it covers. And within that jurisdiction, courts follow a principle called stare decisis.
Stare decisis. That's Latin.
It is. It means to stand by things decided. It's basically the policy that courts should follow the precedents set by previous similar cases. It promotes consistency and predictability in the law.
So it's about sticking with past decisions. But you mentioned earlier some are binding and some aren't. How does that work?
Exactly. Some precedents are binding or mandatory. The court must follow them. Others are just persuasive. The court can consider them, maybe find them helpful, but isn't required to follow them.
Okay, so how do you know which is which? That seems crucial.
It absolutely is. You basically need to ask two key questions. One, whose law applies here? Are we dealing with federal law or the law of California or Florida? And two, which courts within that specific legal system have the authority to bind the court I'm currently in?
Ah, okay. So it depends on the system and the level of the court.
You got it. This leads to what we call vertical stare decisis. A higher court within a jurisdiction binds the lower courts within that same jurisdiction. For example, a decision by the Florida Supreme Court is binding on all lower Florida state courts. The appellate courts and trial courts, they have to follow it.
Makes sense. Higher courts set the rules for lower courts in their patch. What about courts at the same level?
That's horizontal stare decisis. Courts generally follow their own prior decisions. It takes a lot for a court to overturn its own precedent, though it does happen. The huge example is the U.S. Supreme Court in Brown v. Board of Education overturning its earlier decision in Plessy Ferguson regarding segregation. That was monumental.
Wow. Okay. So vertical is up, down, horizontal is same level. And courts generally aren't bound by courts outside their system, right? Like a court in New Hampshire doesn't care what a Vermont court decides.
Generally, no, unless maybe the New Hampshire court is specifically applying Vermont law for some reason in that particular case. And similarly, a federal court deciding an issue of state law usually only has to follow decisions from that state's highest court. Decisions from lower state courts would just be persuasive.
Okay, this is starting to paint a much clearer picture. It's like layers of rules, and you need to know which layer applies and who's in charge at that layer. So what does this all mean for you listening in? Well, really getting a handle on this hierarchy of authority isn't just some abstract legal exercise. It's fundamental.
Absolutely. And look, it might seem a bit daunting at first, all these levels and rules, but honestly, with a bit of practice, understanding this structure becomes almost second nature. It gives you that solid roadmap you need to tackle complex legal questions.
So here's something to think about. How might understanding this structure, this idea of primary versus secondary sources, binding versus persuasive authority, and the different levels, how might that change the way you evaluate or even organize information? Something to mull over.
Constitutions are always the highest authority, followed by statutes, then cases, and then local rules. It's also important to remember the difference between federal and state authorities and between primary authorities, which are law, and secondary authorities, like encyclopedias, which comment on the law. Thanks for listening, and remember, you can be a great legal writer.